Hi and welcome to the show. Most people don't know what to expect when faced with a legal dispute, whether it be in labor law, matrimonial law, property law, debt counseling, or more. We aim to provide the viewers with a better understanding of the laws in South Africa to ensure that the vulnerable are not taken advantage of. In this show, we address specific questions that is posed by you, the viewer, on the platform that will be provided to you at the end of the show. So don't forget to send us your questions via our email or the WhatsApp platform. I'm your host, Fazlaw Abrams, and you're watching the Fazlaw Show. Now, death comes to you at any time. You don't know when to expect it, and it will basically approach you whether you are healthy or wealthy. You cannot avoid it, and therefore you are faced with a sad reality when dealing with the death of a loved one. In this episode, we address that question and that situation as contained in the Administration of Deceased Estates Act, and we answer your questions when you deal with the Master of the High Court in a situation where a loved one has passed on. So be it you are a heir, a spouse, a child, a descendant, or anyone who is an heir contained in the will. So what do you do? And with me today to answer your questions is our legal expert, Fazlaw, who's a conveyancer and an insolvency practitioner. Faisal is a legal expert in property law, legal developments, and also restitution of lands. He is also an expert in contracts, estate planning, administration of estates and trusts, as well as insolvency law. Faisal, thank you for being again on our show. We welcome you back. And today we've got particular questions to answer. So thank you for being on the show again.
Thank you for welcoming me back to the show.
Right.
Thank you.
Faisal, the current position at the Master is ultimately to supervise the administration of a deceased estate, and also to ensure that there's an orderly operation or winding up of the financial affairs of the deceased estate. And in short, I want you to answer the questions to the viewers, which is, what is the current position of the Master of the High Court when it comes to dealing with deceased estates?
Well, Fazlaw, as you know, there's master's office in different provinces, but I'm speaking about the province in the Western Cape because I practice here in the Western Cape. So unfortunately, due to COVID-19, there has been huge delays in the master's office because of inundated with estate matters, a lot of deaths. So the master's office, who is also understaffed, I believe, causes lots of delays. And specifically where you find the delay is when you do report an estate and you apply for letters of executorship, there is a long wait for that document to be issued by the master. So you could be waiting anything between 2 and 8 months, unfortunately, for that document to be issued by the master.
Mm-hmm. And that also has a ripple effect on the issuing or approval of what we call a L&D account. And we'll get into explaining that to the viewers later.
Yes.
And further to that, you have a Section 42.2 as well, am I correct?
Yeah, so like you said, it has a ripple effect. Of course, it has a ripple effect because you can only start commencing with the administration process once the letters of executorship is issued and the executor has now have the right to basically step into the shoes of the deceased and administer the estate correctly. And also the other delay that we found as well is whereby, you lodge documents at the master's office and those documents unfortunately get lost or misplaced, and then there's the delay and then you have to resubmit those documents. So those are the causes for the delays in the master's office, unfortunately.
Thank you, Faisal. For the benefit of the viewers, we understand that there's delays, but let's look at the standard procedure. If you could just summarize that for the viewers.
Yeah, look, so, when somebody passes away, the first thing one should do is, if there is a will, the will has to be reported and submitted to the master's office. If you have a will and you fail to hand it over, it can become a criminal offense not to hand over the will to the master's office. But together with the will, there's...
Summarize it for me. We'll speak to the more special circumstances
yeah,
later. So reporting an estate after that, what happens?
So once you report, you submit the documents to the master scrutinizes the documents, they approve the documents, they issue a letters of executorship, the executor can now start winding up the estate or appoint somebody to assist him or her with the winding up the estate, and that's supposed to take at least between 8 and 12 months, but you can understand the delays, if there's delays, it's going to take quite longer than just the normal period.
So after reporting the estate, you get the appointment of the executor, which is we call the issuing of a letter of executorship.
That's correct, yes.
And then what's Section 29 all about? Can you explain that?
Well, Section 29 is basically the advertisement whereby the executor has to advertise in the local newspaper and report that there is a death of a person, and debtors and creditors should come forward, and report to the executor if there is a debt or if there's a claim against the estate. Yeah.
Right, thank you. And then after that, after the Section 29, the 30-day period has expired, we now know what the creditors, who the creditors are and what the amounts are owed. We then draft, or you would then draft a liquidation and distribution account.
Yes.
In summary, what's a liquidation and distribution
Well, a liquidation and distribution account would basically record all the assets of the deceased. It will record all the expenses, administration expenses, all the claims against the estate, and then it will also record what cash monies are in the estate and the distribution of the assets to the heirs. In summary, that's what the document, and that's the most important document in the process, I would say.
And that document is then signed by the executor. It goes off to the masters, they approve it, and then the masters inform us or instruct us to proceed with the next step, which is a Section 35 advert. Explain that to us.
So the Section 35, like there's two adverts in the estate process. The second one is a Section 35, and that is basically advertising the liquidation and distribution account that gets advertised in the government gazette and in the local newspaper to inform the public out there that there is now a liquidation and distribution account that can be inspected so that they can see whether their claims are reflected in the account or not.
And if not, then they have the right to object.
Then the creditors would have the right to object and say, listen, this deceased owes this company X amount of money. We object to this account. Please rectify the account to include our claim.
Or an heir might not even be listed as an heir, so they have the right to object as well.
That's correct.
And then after that, that would be the end almost. The masters then says, okay, fine. They're happy with everything, and they would then give the attorney the instruction to transfer and distribute. That's where the transfer of the property then takes place into the name of the heirs. Am I correct?
Yes. So after that advertisement is done, there's a 21-day period. That is completed. Now you can proceed with the distribution, either the transfer of assets or the sale of assets or the distribution of assets or monies to the heirs. Yeah.
Fazlaw, we've got another question that I want to answer. I want you to answer, but we're going to have to go for an ad break. Okay. Yes, that's the end of the first segment, ladies and gentlemen. We'll be back after the break to ensure that you get your questions answered. And keep on watching. I'm your host, Fazlaw Abrams. Thank you. Welcome back to the Fazlaw Show. I'm your host, Fazlaw Abrams. After the first segment, we met our special guest, legal expert Fazlaw, and we also discussed the current position at the Master of the High Court. We looked at the potential, or we're about to look at the potential hardships that a spouse might endure during the administration of a deceased estate. And the process at the Master's office are not making it easy at the moment, but we're here with a legal expert to give an explanation to that. Fazlaw, thank you for answering the questions in the first segment, and I know we touched on the hardships that one might find. Can you just give the viewers a better understanding of what type of hardships they might expect when it comes to the death of a loved one?
Yeah, so, when there's a passing of a loved one, obviously, the family is mourning that passing. And now you need to deal with the administration of the estate. So because the family member passed away, you'll find that his estate and his assets or his finances are frozen as such. And because it's frozen, you find that maybe the surviving spouse don't have the necessary finances to continue with the daily expenses. So that's another hardship that they could experience. The other is obviously the long delays which are caused in winding up the estate. So those are the type of hardships that is reality. It affects the surviving spouses, and I always recommend when drafting wills that parties should make provisions for these situations. Yeah.
So when a person passes away, the deceased estate, as we know it, becomes or is now in existence, and we just need you to answer a statement, which is what happens when the appointment is done. So there's two processes. One is a letter of executorship, and the other one is a letter of authority.
Yes.
The one is obviously a simple process, but and we've dealt with what happens with a letter of executorship. So for the sake of the viewers, just give us a brief understanding of a letter of authority and the next step after that.
Yeah, I think the introduction of the letter of authority was to make it more easy for winding up estates which is below the value of about 250,000 rand. So if your estate is in that category, the master would appoint a person who is the master's representative, and they would issue a letters of authority for that person to act, basically. And then that person has the right to collate the assets and then distributes the assets in terms of if there's a will or in terms of intestate succession. So it's a very simple process compared to the letters where the letters of executorship has been issued and adverts and liquidation and distribution accounts. The other process where a master's representative is appointed is a very simple process.
Okay.
And cost effective as well.
Yes, indeed. Another one is there's two documents that particularly is submitted to the master's office. The one is the inventory, and the other one is a next of kin affidavit. Can you explain to the viewers exactly what the purpose is of those particular documents?
So these documents are important documents that has to be lodged with the master's office when you're reporting an estate. So the inventory is basically a document which you inform and complete, and you're informing the master what is the assets in the estate. So you would list all the immovable property, you would list all the movable property, and you will list all the claims in favor of the estate, meaning money's in a bank account, money's invested, etc. That would give you an idea as to what the value of the estate is. So as we spoke earlier about the value being under 250 or over 250, so this document, which is the inventory, will actually give you a written recording of the assets and the value of the estate, yes.
Okay. Then there's special conditions that needs to be dealt with. But before we go, you need to touch on the
other document,
next of kin affidavit.
The next of kin affidavit. So the next of kin affidavit is, as they say, affidavit. It must be signed by the person who is completing it before a commission of oaths. And there you would record who is the surviving spouse, the name of the surviving spouse, who are the children, the names, their date of births. And if there's no children, you need to know who's the parents, who's the brothers and the sisters, and that document is very important, so you can see who are the immediate heirs to that deceased estate. Yeah.
So if it's testate, in other words, if there's a will and those particular parties are not mentioned in the will, and for some reason the masters declare the will invalid for the lack of formalities, then those would be the heirs. And that's, I think that would be the underlying purpose of submitting a next of kin.
That's good.
To ensure that they are disclosed to the masters and the masters are aware.
Yes, they are properly identified, yes.
Correct.
Yeah.
Then the next one, we're looking at the special conditions with regards to minors. So when there are minor heirs in the estate, the Act specifically provides for special conditions. What are those special conditions when it comes to the valuation of
Well,
the
look,
assets?
with minors, the master is very careful when minors are heirs. So in an estate, you need to value assets, and you need to appoint a sworn appraiser to value assets. So you can see what is the true value of immovable property, what is the value of motor vehicles or other movables as such, so that values can be recorded in the estate. So if there is a sale, that sale is in accordance with that value and is not sold under its value.
Thank you.
Yeah.
And that would ultimately be where there's minors, there would be an additional expense for the estate because of the sworn appraiser's fees.
Yes, there is a fee involved for sworn appraisals. However, there's a tariff. So those sworn appraisers have to charge in accordance with the tariff.
Sure. A will is a specialized document. Why is that so? What really needs to be in place for a will to be valid?
Yeah, so look, we have the Wills Act. So the Will Act has formalities. So you as a testator have to comply with these formalities. If you do not comply with the formalities, you know, we cannot be regarded as a valid will. So for one example, if you do not sign the will, it's not a valid will, you know, and if the witnesses are heirs and they sign it, they could be excluded from that will. So there are certain formalities that you have to comply with, and therefore it's important to consult a person who knows these acts and formalities so that the will is compliant and regarded as valid when you do pass on.
And that's not a commission offer, it's preferably an attorney. Because I know out there we find that it's drafted by commissioners and sometimes it's not. It doesn't comply with the formalities, unfortunately.
Look, I mean,
so it's very important that the viewers approach an attorney to have a will drafted.
Beside attorneys, you find a lot of other organizations drafting wills. What the key important is that person must have a knowledge of drafting wills and estate planning. That's very important. Because, you know, it could become a minefield and a disaster situation after the person passes away.
Fazlaw, we need to go for an ad break and we'll continue the conversation after this. That means we've come to the end of this segment and we'll now break for an ad. So keep watching for more answers to your questions. Welcome back to the show. You are looking at the third segment of the show today, and in the second segment, we touched on the statements, specifically statements that was explained by our legal guest expert, Fazlaw Bardin, with regards to the difference of a letter of authority and a letter of executorship. We also looked at the definition or the explanation of the purpose of a next of kin affidavit, together with the inventory, which are documents submitted at the time of reporting the estate. Fazlaw, let's continue. I just wanted to give our viewers a better explanation on a myth that exists. That myth being that if you don't have a will, then your entire estate will go to the estate or the state, which is the government has taken too much already of our people. And that myth needs to be debunked. Can you explain that to us, viewers, please?
So if you pass away without concluding a will, a valid will, you need to wind up the estate in terms of Intestate Succession Act. Now, the Act is very specific. It says and it describes who are the heirs of that deceased. So it could be the surviving spouse who stands in line. It could be the children. If there are no children, could be the brothers or sisters or the parents, you know. So before anything goes to the estate, they would first have to see if there's any relatives. So you can go far as back to nephews, uncles, nieces, you know, those type of things before, you know, any of the assets would go to the estate. So, I mean, in my time of practice, I've never seen it, you know, go to the estate because there's always a relative out there, whether it's a distant uncle or a nephew or niece. So those people would be heirs before the estate can put their hands on any of the assets of the deceased.
And I think perhaps what people misunderstand is that when inheritance, when you don't get the cooperation of an heir and you refuse to provide the bank account details, then you as an attorney are entitled to pay that money into the guardian fund.
Yes.
And for how long does a guardian fund usually get to keep that money before it then cedes off to the state?
Yeah, I think it's 30 years, you are not mistaken. And so, you know, the administrator or the attorney wants to wind up the estate, and if he can't get the cooperation to pay over the monies, you know, he'll pay it to the guardian fund, and then that heir can collect that money from the guardian fund and, you know, prove that he is that heir. But yeah, it's a long period before, you know, that funds, you know, get used by the estate.
Sure. I'm sure they'll be happy to get their hands on it.
That's right.
In community of property, no will. Explain what the distribution would look like with
Yeah,
regard
so
to
if couples are married,
specifically to the spouse, right?
Yeah.
A surviving spouse.
yeah, so if couples are married in community of property and one of the partners passes away, then only 50% of the estate gets, wound up. However, you're looking at a joint estate. First of all, because they are married in community of property, so the surviving spouse is entitled to 50%, and the other 50% is the 50% of the deceased, and that 50% must be wound up either in terms of a will or intestate succession. So if it is intestate succession, you need to ascertain what the value of that 50% is. Because if the value is below 250,000 Rand, it will go to the surviving spouse. If it's above 250,000 Rand, it will go to the surviving spouse and shared with the children.
Right.
Yeah.
Now, a particular case that was held in the courts is called a Bay, BHE, Bay versus Magistrate of Kailicha. And that particularly pertains to customary law. Can you
Yes.
just explain our viewers the importance of the finding or the judgment of that case, please?
Yeah, you see, in that case, what has happened in that case is that the spouse, there was some doubt as to whether the spouse was married to this deceased gentleman, and they had 2 children. So, in terms of the Customary Marriage Act, we found that the assets or the land was going to go to the father, and the father was going to sell the asset, and the surviving spouse and the children would be without any assets. And that was the effect, and Mrs. Bay then went to court and applied so that the recognition of the land and the recognition of the spouse, etc., etc. And that what the court then held is that the act was unconstitutional. It didn't recognize the surviving spouse as such. And then what they held is that any customary marriage should be wound up in terms of intestate succession as well if there is no will. And that was the outcome, which was a very important outcome of that case, so that you find that the surviving spouse and the children can now be protected, and they can be entitled to inherit in terms of the Intestate Succession Act.
Thank you, Faisal.
Yeah.
With regards to a redistribution agreement, there are options for the heirs to enter into that redistribution agreement. And ultimately says agreement. So if all the heirs are not in agreement, there won't be a redistribution of the assets. But explain to me, what is a redistribution agreement for the benefit of the viewers?
Yeah,
please?
so look, the heirs can come together and they can say, listen, there's different assets in the estate, but we want to redistribute those assets. So they can say, listen, the A can get the motor vehicle, B can get the bicycle, and C can get the lawnmower, and that's a redistribution of assets. They then enter into this written agreement, and each heir needs to sign and agree to this redistribution of assets. Unfortunately, if one heir does not agree to this redistribution, you cannot proceed and wind the estate up in terms of a redistribution agreement.
Sure.
Yeah.
One particular problem that we find out there is where heirs realize that instead of entering into a redistribution agreement at municipal value for the asset, the immovable property, which is the biggest one,
Yes.
There's an option of selling the asset if there's not sufficient funds to pay for all the expenses, or the spouse, let's say the spouse or one of the heirs are not able to pay out the balance of the heirs, what they entitled to. An heir can then insist that the property be sold. So the question that I have for you from the viewers is, can that heir insist that the property be sold at market value?
Yeah, like I said earlier on, when it comes to assets in the estate, you need to have it appraised, right, or valued as such. So yes, the heir can insist and say, listen, I want this asset to be appraised or valued at a market-related price, so that when it is sold, the property or the asset is sold at the market-related price. Because otherwise, I, as the heir, is going to be prejudiced. You understand? If you sell it under the market value, I'm not going to get my fair share at the end of the day. So very important, the heirs can insist that assets must be valued at market-related prices. Yeah.
Faisal, thank you for being a guest on our show. You've been here for a number of times. We're looking forward to you having on our show again. That comes to the end of the question and answer show. Thank you.
Thank you for having me.
Well, that brings us to the end of the show. So please, before you leave, don't forget to send us your questions via the platform. So our email address is info@fazlaw.co.za, and our WhatsApp number is 082 495 8989. If you miss it, it will reflect on the screen. So don't forget to follow us as well. We are on Twitter, YouTube, Facebook, and Instagram. I'm your host, Fazlaw Abrams, and thank you for watching the Fazlaw Show on Cape Town TV.